Good afternoon, everybody. Thank you all for joining us for our 6th annual Lunch and Learn virtual sessions. The League of Women Voters hosts a legislative week and sometimes a legislative day at the Capitol. This is part of that series, and in 2025, we have planned 5 legislative week sessions during the lunch hour. Hopefully, you're enjoying a delicious lunch and taking the time to hear from expert speakers on 5 different topics. If you have not registered for any of the other topics, please be sure to register for them. And Grace, if you don't mind putting the link that you see there in the chat for everybody, that will be wonderful. Today, we are going to hear from 2 experts on federalism and states' rights, the intersection of federal and state laws, and the impact on Arizonans. Our presenters today are Professor Sean Beienburg and Professor Justin Weinstein-Toll, who we will introduce further. I am Penny Sharan, the president of the League of Women Voters, and I am moderating this session with our wonderful youth leader from Greater Tucson, Grace Mary Thesfield. And we both will try to make this a fun experience and answer questions. Before we get started, I would like to explain what you should anticipate in today's program. The welcome, as I have explained. I will go over a couple of logistics, and then we'll talk about how we're planning on moderating, okay? We'll handle the Q&A as time permits, and Grace is doing the heavy lift on the back end, monitoring the Q&A. Some of the answers we may be able to give you directly, but some we will bring up during the session for our presenters to answer. For today, the tips for you to enjoy your lunch and learn: please mute your microphone. Do not use the chat feature to answer questions. Please use the Q&A feature. Locate the Q&A feature in your Zoom toolbar. Don't use the chat, and that's because when you use the chat, not all the moderators and hosts can see your questions. Whereas if you post your questions in the Q&A, all of us can see it. Time permitting, we will present the questions to the speakers. If there are unanswered questions, it's important that you leave them in the Q&A, and we will do our very best to get answers from the speakers. Post the event, we will be sending out links, a link to the video and to the recording, and also answers to specific questions. Today's session is being recorded and will be available on the League of Women Voter Arizona's YouTube channel. We are at LWV Arizona 3069. Before we get started, this is very standard for us to remind everybody about who the League is and how we educate our citizens in the framework of empowering voters and defending democracy. We envision a democracy where every person has the desire, the right, and the knowledge and the confidence to participate. We're a nonpartisan grassroots organization. We are an all-volunteer organization, and we work to protect and expand voting rights to ensure that everyone is represented in our democracy. We empower voters and defend democracy through advocacy, education, litigation at the local, state, and national level. And it's important to note that today's series is part of our advocacy and education work. We take an action on any particular issue only when we have a position addressing it. And we have many positions on both voting rights and women's rights. If the members have not studied and come to consensus, the League has no position, and therefore we take no action. We might have a comment to make, but we would not be advocating through education, litigation, and advocacy, okay? Usually it takes about 1 to 3 years in which we undertake the pursuit of facts and details, both positive and negative, and come to consensus about the policy. I'd like to take a minute to share with everybody on the call the 2025 Defend Democracy framework from which we will be doing our work as the League of Women Voters of Arizona. This framework comes to us as guidance and as directives from the League of Women Voters of Arizona, of the United States. We are being assaulted with so many issues that are an impact on our democracy. However, we only have capacity to react and to take action on those things. So we believe it is prudent to do the most about those things we can do the most about. We cannot take on every single issue. We have neither the capacity as an all-volunteer organization to react to all of them. Our campaign for the 2025 is Women Defend Democracy campaign, and we're going to be leading with the League Gold Standard priorities, which is democracy, education, and election administration support, restore and defend voting rights protection, abolish the Electoral College, protecting democracy organizations and institutions, reproductive freedoms. We strongly oppose any efforts to have a national abortion ban. With that, we are going to bring on board our two speakers. So Grace, if you will highlight both our speakers, it would be really appreciated. Our first presenter is Professor Sean Beienburg. He's the Associate Professor and Associate Director. Yay. Okay, great. Of the School of Civic and Economic Thought and Leadership, SCETL. He's also the director for Center for American Civics. He also leads the project. He's the project director for the Arizona Constitution Project Initiative, and I hope we will hear something about that. And certainly as a league, we're very eager to figure out how we might collaborate with you on your work on that front. His teaching and research, as defined, his scholarship is in the U.S. Constitution and Constitutional Law, Federalism and State Constitutionalism, Arizona Constitutionalism, Executive Power, both presidential and gubernatorial, 19th and early 20th century political and constitutional history. Education is from Pomona College, but you are an Arizona native, as I understand.
That's not strictly a native. My grandmother's been out here forever. I was born in a little period when the family was in Utah, but
okay.
I'm an old timer.
Okay,
pretty close.
All right. And his PhD is from Princeton University. I'm going to move on to introduce Professor Weinstein-Toll, who is also going to be presenting. And I'm doing the introductions up front so we can give them the most amount of time to tell us what we're eager to hear on this topic, okay? Professor Toll is a professor at the Sandra Day College of Law. He was a former Thomas C. Gray Fellow and lecturer in law at Stanford and trial attorney in the Civil Rights Division of the DOJ. Expertise is in structural constitutional law, specializes in state and local courts and government, focuses on reconstructing public law theory to better reflect the real-world complexities. Boy, do we need to understand that now of governmental institutions and the daily human experience, which is of great interest to us as the League. He has written extensively about how state and local governments can both frustrate, and we feel quite frustrated at this time, Professor Weinstein-Toll, and strengthen federal power, particularly in areas like federal civil rights, land and voting rights, okay? Graduate of Yale Law, Harvard University, and Stanford University. With that, I'm going to turn it over. I'm going to stop sharing my screen, and I'm going to turn it over to Professor Beienburg. And Grace, you can just spotlight Professor Beienburg at this time, okay?
I'm going to put on my PowerPoint here real quick. Hang on a second. All right, is that showing up okay? PowerPoint showing on there okay?
Yes, yes.
All right, perfect. All right, so again, thank you very much for having me. So I've sort of envisioned this as kind of a little bit more kind of basics and core architecture of federalism, and to lay out some of the relevant case law and ideas that I think will be relevant in the next couple of years. But this is a little bit more sort of background in some sense. So as she alluded to, I teach in the School of Civic and Economic Thought and Leadership, which is a new program at ASU, focusing on civics, constitutionalism, et cetera. And we've really tried to do a lot of public outreach, unlike just professors talking to professors. So I'm always glad to get an opportunity to do something like this. So I want to put a quote up on here really quickly that I think maybe is a little surprising. The doctrine of regulation and legislation by masterminds has been too apparent at Washington to bring about government by oligarchy masquerading as democracy. It is fundamentally essential that practically all authority be centralized in our national government. Then the speaker goes on to say, we're safe from this danger as long as the individual home rule of the states is scrupulously fought for and defended, right? So here's somebody basically critiquing, by masterminds, they mean bureaucrats in Washington, D.C., a concern that oligarchy will be the inevitable outcome from consolidating power in Washington, and that we must instead defend the home rule of the states. And if I were to ask you who says this, you would think this sounds like Clarence Thomas or Rand Paul or Ted Cruz or somebody. But it's actually Franklin Roosevelt when he's a governor before he becomes president of the United States. And I could bury you with more quotes from this where he's complaining about loose constructions of the Commerce Clause and any number of other things, where he and his allies are complaining Calvin Coolidge is a big government nationalist. And that's all to say that I think that we often have this narrative that federalism and states' rights is a fundamentally conservative doctrine. And I think that this may be something that progressives in the next few years may begin to need to rethink as they're thinking of ways, if they're interested in pushing back against perhaps overreach by the Trump administration. So I'm going to start basically just with some basic architectures of federalism, and then, like I said, walk through sort of a few myths that are relevant. And in the course of that, I'll be talking about the case law. Right, so again, really basic summary of federalism, so to make sure everybody's on the same page here. 10th Amendment sort of spells it out most concisely. The powers not delegated to the United States by the Constitution or prohibited by the states are reserved to the states respectively or to the people. Now, what this means is that under the Constitution, there is a presumption on behalf of the state power to regulate for health, welfare, safety, and morals. Conversely, and this is called the police powers in con law nerdery, but police powers doesn't mean nightstick and a badge. It means polity or society or government. Conversely, there's a presumption against federal power to regulate. So what that means is effectively that the state governments are presumed to be able to act unless something in the Constitution tells them no, or a federal law that is authorized by the Constitution tells them no. Whereas conversely, the burden of proof is on the federal government to show that they have this power to regulate. So this gets spelled out similarly, I think, well, by Federalist 45. The powers delegated by this Constitution to the federal government are few and defined. Those which are with the states are numerous and indefinite. And so this really helps us think about, I think, the distinction between what we would see as a unitary government and a federal government. So in a unitary government, primary political power is held in a single national government. In a federal government, primary political power lies with a multiplicity of subnational governments, say states or provinces. Similarly, in a national government, the central government holds presumptive authority to govern everywhere that you haven't told it no. And in a federal government, the central government only holds a specific set of powers that are given to it. So this is how the US Constitution's architecture operates. The central government in a unitary government can dissolve and create subnational governments as they see fit. Conversely, in a federal government, the central government is created by the subnational governments. And so, for example, the contrast between this and, say, the United Kingdom, I think, is illustrative. At times in recent British history, the British government at Parliament in Westminster has dissolved or suspended or frozen the other parliaments. No matter how much we annoy them in Arizona, they can't close down the Phoenix government, the state government in Phoenix. It has its own independent sovereignty. And I can talk more about this in the Q&A. I'm just going to really briefly pass over this. But I think this is actually what the American Revolution was fundamentally about. That the British understood the British Empire to be a unitary government where Parliament had the authority to set all policy, both foreign and local, including taxation. And the Americans came to understand the British Empire to be something of a compound empire, more of a federal empire, where domestic political power was held by whatever the relevant local government was, Parliament for England, and the local, say, the House of Burgesses or the Massachusetts General Court for the state, for the colonies. And just, I think this is a striking finding because we sometimes have this narrative that federalism was sort of stuck in as basically a concession to Southern racism, but it's actually one of the most unifying features at the time of the founding. And so I've done some work on this, but if you look at state constitutions, this is the reference is made to my work with the state Arizona Constitution Project. But if you look at state constitutions at the time of the founding, the states that have explicit language like the 10th Amendment in their constitutions, it's the New England states. It's not South Carolina. It's not Georgia. So if you want to use this, it almost suggests an inverse between enthusiasm for this federalism idea and sort of commitments to slavery. So it's just, again, I think we have this narrative that federalism was like the 3/5 clause or something. It was made to keep sort of the southern slave states on board. I would say nothing could be farther from the truth. This is fundamentally a unifying American doctrine at the time of the founding. And so you see this in our Constitution, where it's this sort of mixed system between federal and national. So the scope of federal powers are that of a federal government. They're limited and enumerated. Their execution, however, is national. A single president executes that directly on citizens. The selection of the upper legislative chamber represents this mixed system where the Senate represents the state's sovereignty, of each sovereign state being equal. The House represents population. This is somewhere where I probably have a different take than many of you folks. But the Electoral College, for example, I think accurately and faithfully represents this fact by tabulating the number of senators is a federal, indicates federal, and the number of representatives indicates national. We can talk more about that in the Q&A. The amendment process is mixed, and the joining of the Constitution is federal. So it's this mixed system, which in some ways tilts toward federal and in some ways tilts toward national, but is I think, fundamentally a federal system. So I want to turn to a couple of myths that I think will be helpful as we think about federal power in the coming years. So one, we have this myth that federal law is supreme over state law. But in fact, federal law only trumps state law when the Constitution authorizes that, right? So if you look at Article 6, the Supremacy Clause says this Constitution and the laws of the United States made in pursuance thereof are the supreme law. And there's a quote I have there from Alexander Hamilton in Federalist 33, in which he says, those acts that are not pursuant to the constitutional law are acts of usurpation. That's the sort of the boring old-timey way to say it. There's a funnier version that I like from Elihu Root, who is Theodore Roosevelt's Secretary of War and State, basically his right hand, who says, an enactment by Congress not in pursuance of the Constitution has no more legal effect than basically the resolution of a debating society, right? So for something to have that supremacy, it has to be constitutionally authorized. So it's the constitutionalism that makes it supreme, not federal over state. Similarly, and this harkens back to what I flagged at the beginning with the FDR quote, we have this sort of narrative that federalism basically has been a fundamentally conservative doctrine. And I would say pretty much, this is the subject of my scholarship, but I would say pretty much through the New Deal, federalism was cherished across regional and ideological divides for most of American history. We have this narrative, I think, and I think it's a mistaken one that's a result of listening to the lost cause understanding of history, that the Civil War is fundamentally about national power versus state power. But if you actually go back and look more carefully at both what the Confederates thought that they were fighting about, and frankly, what the Republicans thought they were fighting about, that's really not what the fundamental divide is. It really is about slavery. It's not federalism, which is why in the years afterward, when they're debating how do we reconstruct the South, you have the radical Republicans, except for a very, very small number of them, really are concerned. They're trying to figure out how can we rebuild the South without violating federalism. And they go through an awful lot of work to come up with theories to explain that, because they do not want to empower the federal government basically one bit in dealing with, say, Pennsylvania. So that's how you have Thaddeus Stevens, who I think most of us would recognize as sort of the most prominent and probably most radical of the radical Republicans, fretting, where is the warrant in the Constitution for a sovereign power to rebuild the domestic institutions of a state? He decries this as rank, dangerous, and deplorable usurpation. And then finally, relevant to Arizona, George Hunt, if any of you folks have ever seen the pyramids outside Papago Park, this is Arizona's first governor. I've got a quote from him through a letter he wrote to another governor. The old idea of the right to a state to nullify federal laws is gone. It does not follow that while the federal government is supreme in its field, the states are not supreme in their own. But then look at this part here. Where new questions come arise that were not contemplated by the makers of the Constitution, they should be handled by the states in accordance with the reserve power of the 10th Amendment or granted to the federal government by proper constitutional amendment rather than strained legal decision of the court. So if you peel this quote aside, what do you see here? You see him defending the original intent of the Constitution as the proper way to understand it, a strong presumption on behalf of federalism, and a criticism that if we do need to expand federal power, it must come from a constitutional amendment rather than a strained legal decision of the Supreme Court. If you were looking at that, you would say, that sounds like Clarence Thomas. That sounds like Antonin Scalia. That sounds like Neil Gorsuch. And yet, this is from the guy who was the most left-wing governor of the most left-wing state in the Union, right? Very much taking a very different perspective of the way that politics sorts out between the way we look at it today. But if I took that name off, you would think that sounds like basically a conservative originalist. But at the time, throughout most of American history, people's views of policy did not overlap with their views of constitutional theory. Those collapsed together today, but they didn't for most of American history. I want to say a few words about the Commerce Clause, which I think will actually connect back to the point about the national abortion ban. It was one of the things that was flagged here. Right, so the interstate commerce power is power to regulate with foreign nations, commerce with foreign nations and among the several states. It's worth emphasizing for any grammar nerds, among is for this purpose supposed to be between, but it's involving multiple states. So basically, this is the idea that Congress can regulate commerce between the multiple states. Hence, we describe this as the interstate commerce power. And you see James Madison arguing that this was, in fact, one of the very few changes in terms of adding to new powers rather than better execution of the original laws. But again, going back to Franklin Roosevelt, we have a quote from him in the 1920s, fretting about the elastic theory of interstate commerce that's been used to stretch the breaking point to cover certain regulatory powers desired by Washington. Now, Roosevelt changes his mind on this and decides, in fact, he likes this elastic theory of interstate commerce. But basically, in 1929, 1930, he sounds like the fiercest critics of this on the Supreme Court that he's going to fight with in a few years. So how does this change? Well, there's the case that I think is the most important foundational case for thinking about federalism is a case called Wickard versus Filburn. Backstory here, there's a farmer who's growing grains on his property, feeding them to his animals. The grains, from his perspective, don't leave his farm. He's not selling it. And he's charged with violating federal quotas on grain production. And he argues that this is unconstitutional because for the interstate commerce power to operate, federal regulations have to be about both buying and selling a good or service and a multi-state transaction. So Filburn wonders how the federal government can regulate something that isn't either interstate or commerce, much less both at the same time. And the Supreme Court concludes that, in fact, that can be regulated because he may not be buying or selling or even directly connected to multi-state economic activities. But if everyone did the same thing, that aggregate effect would modify the macro level demand of the good. My students always hate this case, but I tell them for better or worse, this is basically the reigning doctrine of federal power today. Almost everything that the federal government does today is justified under this case. But effectively, since the federal government can regulate an interstate market, it can pass regulations that down the line will eventually affect that, this sort of long causal chain. And that remains pretty much the doctrine for about 50 years until a case called U.S. v. Lopez in 1995, in which the Supreme Court pares that down a little bit. Basically, in this case, the federal government was regulating whether you could bring a firearm onto a school. And the Supreme Court strikes this down 5-4 with an opinion by William Rehnquist. And what Rehnquist basically says, whatever the faults of that Wickard case in sort of distorting federal power beyond the Constitution, we can keep it as a precedent, and we're not going to worry about the difference between interstate and intrastate commerce anymore. So in effect, Rehnquist says we will concede as precedents that we're just going to say is the commerce power, not interstate, not intrastate. But Rehnquist goes on to say that power has to be used for fundamentally economic things. It can't be used as a pretext for non-economic police powers regulation like health, welfare, safety, and morals, which the 10th Amendment leaves with the states. And so Rehnquist's argument is that gun possession in schools is fundamentally a local public safety issue. It's fundamentally about core state police powers, even under an expansive case like Wickard. So in that case, Rehnquist says the Constitution leaves the states with the authority to regulate health, welfare, and safety in this regard. And indeed, the states are already handling this issue, right? Every state basically has a regulation like this. And I flagged the Lopez case here because I think it has direct relevance to, for example, concerns about whether the federal government would try to pass a national abortion ban. One thing that's striking is back in 2006, 2007, when the federal partial birth abortion ban was passed, there's actually a concurrence by Scalia and Thomas saying nobody raised a 10th Amendment argument about this. Nobody cited the Lopez case. Arguably, pretty decent case could be made that the interstate commerce power is not supposed to be used to regulate abortion. But progressive lawyers at the time didn't want to take the case because they were convinced federalism was basically like a right-wing thing. So my point is that this is potentially a tool that progressives may be interested in reusing again, since this remains effectively the major framework, Wickard plus Lopez, in dealing with federal power. I want to now turn just to the discussion, since it has implications for thinking about sanctuary politics, which are relevant here. We have this myth that states declining to enforce federal law is the same as nullification. But basically, the framework under U.S. constitutional law is that states cannot be required to enforce federal law, but they can't obstruct it either. So both nullification, which is the proactive obstruction of federal policy, and forcing of the states to implement federal policy are inconsistent with the American tradition. So nullification is pretty much universally regarded, even by states' rights advocates, as unacceptable. Conversely, the doctrine is called anti-commandeering, but the states can't be made to insist in federal enforcement of laws. It comes from a case primarily called Prince versus United States from 1997 by Scalia, which builds on a case from Sandra Day O'Connor in 1990, a few years before that. So, for example, the feds can't make the states do prohibition. The feds can't make the states do marijuana legalization. And the feds can't make the states do immigration policy or block their sanctuary cities and state policies, with the asterisk that some of the states in their particular sanctuary state laws do go beyond passivity to active obstruction. So, for example, the Trump administration has been bringing suits against New York and Illinois for effectively having state officers tip off people who they think are the federal government is going to come for. That probably counts as nullification. Conversely, a state merely saying, we're not helping, we're not participating in this, that the state should win. So to the extent that the Trump administration seems like they're threatening to push them around financially, the states probably have a pretty good case under this anti-commandeering doctrine to say, you can't make us do this. So the basic framework for immigration for this is that the states don't have to help, but they can't get in the way if it's a legitimate federal power. So we see this again from the quote from Justice Scalia and Prince. The federal government cannot issue directives requiring the states to address particular problem, nor command the state officers to enforce federal regulatory program. This is inconsistent with our system of dual sovereignty. And so just as a case study of this, again, with marijuana for the last few years, right? The Controlled Substances Act creates a federal prohibition on marijuana. California, like a lot of other states, legalizes it for purposes of state law. That doesn't mean that the feds can't enforce it with the DEA. The states just can't interfere with that activity. So I want to flag just two more brief cases that I think are going to be of relevance going forward. One is the Washington versus Glucksberg case from 1997. This is the framework that the Supreme Court has adopted in interpreting what are so-called unenumerated rights in constitutional law, so rights that do not seem to be fairly explicitly drawn from the text of the Constitution. So this is the framework, for example, that was used in the Dobbs case, where the court says, the Glucksberg standard basically says, unless it's in the text of the Constitution, because our job is enforcing the Constitution, but we will only enforce unenumerated rights if we can demonstrate that these are deeply and objectively rooted in the nation's history and traditions, which in that case, because they said abortion had sort of a mixed record on that they were no longer going to judicially enforce it. But the flip side of that is actually a states' rights position, which is Arizona, like many other states, then went through and said, well, that might not be a federal right, but we actually think this ought to be a right that our state guarantees, that the state constitutions, that the federal constitution is a floor and not a ceiling. So in that case, in the 2024, Arizona used its state sovereignty to add an additional state constitutional right to guarantee a right to abortion in the state constitution. So that, I think, is the framework. But as the court basically withdraws from that, it empowers the states and state officials and citizens using the initiative process to add those kinds of rights through their state constitution. So we've become accustomed to thinking that rights only exist if the Supreme Court says that they do, but there are actually a lot more tools, and in some sense, a much easier tool here in the state. So with that, I'm going to stop here. So thank you very much. I just want to flag, if you're interested in learning more about our department's offerings on the academic side, undergraduate, public programming, scuttle.asu.edu. But we also do a lot of work on K-12 civic education and other materials. So if you're interested in learning more about federalism, we have basically materials that are written for adult learners as well on that. We've basically gone through and created the materials attached to the citizenship test, but much, much more thorough with abridged primary sources. So with that, I'm going to stop my screen share and hand it over.
I'd like to, we have a question that
Yes.
I'd like to share with you, and we're going to try to answer this. I'm hoping you can answer it.
Yep.
Okay. What happens to states where the governors say that they will not obey you kind of touched on it, but maybe if you can elaborate a little bit further, that they will not obey federal laws where they're working to deport immigrants. Can states limit ICE enforcement?
States cannot limit ICE enforcement. That would count as nullification. So if the federal government has, whether the federal government's immigration powers is a sort of its own kind of odd constitutional doctrine, but most folks think that the federal government does have that power. So conditional on that, the states cannot interfere with ICE enforcement. That if they do that, so I would say Supreme Court case law is pretty clear that that's unacceptable. But so when they say they will not obey federal laws, federal laws, federal law, the immigration laws effectively create mandates for the federal government to enforce that. So a state can choose to do more than that. Arizona, for example, has passed over the years several laws basically saying we will assist with that. We'll do more on that. So a state is not required to help, but a state cannot actively obstruct. So that's basically what the next few years of the immigration stuff is going to be, basically using that framework, and it's going to be very fact specific. So for example, if the federal government, they've been talking about sort of cutting off funding to sanctuary states and sanctuary cities, depending on how that's drafted, the states probably will win that, particularly if it's pre-existing funding. If it is basically saying we will not condition new law enforcement grants unless you do that, that might be a little dicier. But if a state is actively obstructing, so for example, the New York, I guess it's called the green something law, where they say like if a federal ICE official like looks through our state records, we will then tip off anybody whose records were looked at. That almost certainly would be illegal under federal law. So basic framework, states cannot be required to help, so they can just sit on their hands, but they cannot do anything to proactively obstruct what the federal government is doing on immigration. It's a great question.
Yeah, great question. We have another question. Maine governor says she will see the president in court over girls' sports issues in public school. Is this covered by the
Prince case?
Yeah, the Prince case. Is Maine right?
I'm trying to remember the exact framework on that. The wrinkle with that is that that's I think a Title VI case. So effectively, the federal government funds, I want to say about 8% of the costs of public schools. That was originally actually created effectively as a way to basically incentivize the states to do desegregation. Before that, the federal government really didn't have a role in funding schools at all. It was controversial when they did that. My memory, I haven't looked at the Maine case exactly, but my memory is that that is attached to, basically the argument is that it's, that because the state government is, because the school system is a state government creature, that it's interacting with Title VI in that regard. It's not a Prince case. It's not a coercion case in that sense. But it's related. That's a statutory issue. I'm trying to remember exactly which chunk of, maybe Professor Weinstein-Toll, when he jumps on, can clarify on that. But my memory in that one is that it's basically that the Trump administration is interpreting some part of federal civil rights law, which regulates state governments, to make that case. But I haven't looked into the details of the Maine case very well.
Professor Beienburg, I want to be sure you are able to view any of the questions in the Q&A. you've answered the two that were posted, but just in case other questions show up, please feel free to do
Yep.
that. And I am going to now switch. And thank you so much, but I'm going to bring you back because I'm
Okay.
sure we're going to have more questions and there might be some back and forth between you and Professor Weinstein-Till. So I will feel free to go off camera and we'll bring you back shortly, okay? Great. I am going to focus on Professor Weinstein-Till. Thank you so much for joining us and turn it over to you.
Okay, fantastic. Can you hear me?
Yes, we can hear you.
Wonderful. Okay. It's great to be here with you all. Thank you so much for inviting me and us out here to speak to you all. It's wonderful to get out of the academy and into the community where a lot of the real sort of work, the day-to-day work of making sure, you know, the election system is working happens and that democracy happens and all that. So, and I especially appreciate the League of Women Voters, nonpartisan and educational mission. I think that's really important. So Professor Beienburg talked about federalism, states' rights generally, and I am going to sort of move us into the context of elections and voting rights in particular. Federalism is a really complicated set of sometimes very abstract questions. Questions of power, who has the power in what circumstances? Is it the federal government? Is it the states? But it plays out quite differently in a number of policy contexts for various reasons. And elections are no exception to that. There's kind of election law, federalism sort of has its own flavor and its own sense. And so to understand what's happening with any given election rule, whether it's a federal rule or a state rule or a local rule, you kind of need to understand the surrounding sort of constitutional and statutory structure. And so I'm going to start out by talking fairly broadly about a sort of framework for federal, state, and local dynamics in the context of voting rights and election law. And then I'll move from there to how that framework might apply to contemporary issues and some issues that Arizona is sort of salient to Arizona right now. Okay, so let's start at the beginning. Professor Beienburg talked about the 10th Amendment. That's fantastic. It's always great to start with the Constitution. And the Constitution has an elections clause. So starting with that, I'll just sort of read it out here. The times, places, and manner of holding elections for senators and representatives, basically the administration of elections, shall be prescribed in each state by the legislature thereof. So the sort of primary responsibility for holding elections is going to be with states. The federal Constitution says that. But the Congress may at any time by law make or alter such regulations, except some small thing. So it's already kind of this relationship. There's a primary administrator of elections, even federal elections, that is the states. But Congress can chime in when it decides and make its own federal election laws. So, in the sense that in some areas in federalism, there's sort of the federal domain and the state domain. In elections, it's kind of mixed up. It's all mashed together. And what that means is, well, it means a lot of things, but what it means sort of first of all is that elections are this really complicated institution and a kind of a tapestry of federal and state laws and actions. And it's again historically been that states have been the sort of primary administrators of elections, and the feds have only chimed in occasionally. But when the feds do chime in, it tends to be very important and it tends to be meaningful. And so there is a back and forth between the federal government and the states. So that's one thing. election law federalism is complex. Another thing is that elections are highly, highly decentralized. So federalism overall is sort of a form of decentralization. It's policymaking where some policymaking exists at the federal level, but much policymaking exists at the state level. The Constitution does sort of decentralize election policymaking down to the states. But the interesting thing about election law is that it doesn't end with states. In election law, decentralization continues all the way down to local governments. And so people talk about elections being hyper-federalized, that they sort of have been pushed all the way down from the federal government down to the states, and then again down to local governments. And so the reality of elections is that we have thousands of local governments, counties, townships, et cetera, that administer elections. And they administer federal elections as part of what they administer. So we have this thing, these federal elections that are so important to the sort of federal, fabric of our world. And they're being administered potentially by very small local governments. I think that's actually a kind of incredible thing. I can't really think of anything else in our policymaking world that is that important, that's also decentralized to sort of such a degree. So to amend what I said earlier, it's not just federal and state laws that are coming together to create this elections ecosystem. It's also local laws and local officials. And so we're immediately in this really complicated ecosystem. And there's a lot to say about it, and I'll say just a few things. So one thing I want to mention is that there are 3 levels of government implicated in every federal election, and governments don't always get along. In fact, governments often don't get along. States sometimes don't get along with the federal government. Local officials are sometimes in tension with their state officials. And elections require this really careful, sort of precise coordination between the federal government, the states, and local governments. That's a huge challenge, right? So right from the start, in some ways, the decks are sort of stacked against elections in a way. They're hugely challenging to get right, and there is room for error. And when I say error, I mean good faith error in a way, right? There's certainly room for bad faith error as well, but there's a lot of room for good faith error. I worked at the Department of Justice in the voting section, and part of what we did was we would occasionally monitor elections around the country. And I had the chance to do that a few times in different parts of the country, and I would meet with the local elections clerks and the people who did the administration and the people who did the vote counting and all that. And they were extremely hardworking. And I never met someone who I thought, this person is not doing their best. But they had a lot of work to do. They had to coordinate with their poll workers, hundreds of poll workers, right? They had to coordinate with with the people who were running the polling places. They had to coordinate with other county officials. They had to coordinate with state officials. And they had to coordinate with the feds when the federal government was monitoring. So it's this really sort of fragile and complex system kind of by design. And every time we have a successful election, which frankly is quite often, it feels a little bit like a miracle, I think, to anyone who studies elections. Okay, so that's one thing. It's complicated and there's a whole lot of room for error. There are good things, though, too, about this incredible decentralization. For example, because elections are so decentralized, it would be very challenging for one person to sort of corrupt an entire election, right? There isn't kind of one office in the federal government that runs all of this, right? And if you kind of get the wrong person there, then you're in trouble. There are 50 states in the District of Columbia, and each state has tens of counties. And so there's a little bit of a safeguard there against too much kind of widespread election tampering. And that, I think, should give us some confidence in our election system, right? If you want to hack the presidential election, you can't just do it at the federal level. And you can't even just do it at the state level. And there are thousands of these local governments. So there's something to that. And there are downsides as well. The sort of flip side of that is that there's an incredible variety when it comes to the way that local governments administer elections. There are some local governments that have extraordinary resources. There are some local governments that don't. When I was monitoring elections, there was sort of this kind of head-spinning experience where you would go to an election in a city where it might be, the elections might be in a school or a public library, and there are lights, there's good lighting, and there are couches or whatever. And then you might go to a barn in a rural community where there, where there isn't great electricity or there isn't great water provisions, right? I mean, so there's an extraordinary diversity in how elections are administered. And because of the number of polling places out there, it's very hard to monitor all election places at once. And so it's hard to know whether things are really sort of going right or not. During a presidential election, there is a fair amount of monitoring because there's a whole lot of public scrutiny of those elections. The campaigns are doing monitoring. Sometimes the Department of Justice is doing monitoring. Sometimes external groups are monitoring elections. And that can be really useful for sort of ferreting out any potential problems. But on midterm elections, off-cycle elections, there's much less scrutiny. And even in high scrutiny elections, in rural communities, there may not be as much sort of monitoring of those things. So the flip side of kind of that confidence that it's hard to hack an election is that we maybe don't have as much confidence that things are running as smoothly as we would like. And there are sort of bedrock federal laws that regulate the voting process, things like the Voting Rights Act, right, which prevents denying someone the vote based on race or color. There are sort of bedrock federal cases that say, you can't deny someone the vote based on their socioeconomic status. And we hope that this is being complied with everywhere. And there might be lawsuits that arise where there are problems, but we also can't be sure that there's 100% compliance because these polling places are sort of low visibility areas. All right. And to make things kind of even more, I think, interesting and complex, in Arizona, we also have many tribal communities. And so local government officials need to be consulting with tribal leaders, with community leaders to make sure that the voting procedures that the local government officials are instituting are also effective in tribal areas. All right, so given all of this sort of like big, complex, symphony or mess or whatever you want to think of it as that elections are in the country, how do you move forward as an advocate, right? As someone who cares about voting rights or as someone who cares about democracy? And one really wonderful thing about decentralization in elections, which I think is kind of Professor Beienburg was maybe referring to as well, is that there are federalism is an opportunity for exercising power at many different levels. All three levels of government, the federal government, the states, and the local governments affect elections. That means that if you want to make change, you can target any of those levels, right? So maybe you want to have the most impact possible. And so you start with the federal government and you try to make headway. And the truth is that it's very hard to get anything passed at the federal level for a whole lot of reasons. And so maybe you're locked out of the federal government because your preferred party isn't in power, or because you're frustrated by the filibuster or whatever, right? And so then you have your state. You can advocate at your state level. And maybe your state level is less sort of gridlocked than Congress is, and you're able to make progress there. Maybe your preferred party is in power at that state and you can try to make change, but maybe you're locked out of your state government too. You can still go down to your local government and advocate there, right? You can, to the extent that local governments have control over some aspects of election administration, you can elect the county register or the county recorder who you think is going to be most protective of the priorities that you yourself hold. So in many ways, federalism opens up all of these avenues of advocacy, and that's a fantastic thing. And Professor Beienburg is absolutely right that sort of, since the civil rights era, the idea of states' rights was sort of associated with conservative causes. And he was saying that, progressives might want to think differently about that. I actually think progressives have been thinking differently about that. Maybe since the 2000s, certainly progressives in the legal academy have been writing about using states' rights for progressive ends. But federalism is ultimately an opportunity for exercising power. And so if you want to make change, you should look to see where you can exercise power in any context, right? It might be the federal government, but it probably won't be, because the federal government is, again, really hard to make change, is a place where it's hard to make change. So I think Professor Beienburg is exactly right that that what federalism allows is sort of the opportunity for advocacy in a whole bunch of different sort of ports of entry into your preferred policymaking areas. There has been some movement at the federal level, which I want to just mention. In 2021, the House passed a bill called the For the People Act. It was a massive bill, and it would have been, I think, one of the sort of most, the sort of broadest, certainly election laws, maybe since the Voting Rights Act, but it would have regulated states in the areas of automatic voter registration, same-day voter registration. It would have prevented, or would have sought to prevent, long wait times at polling places. It would have provided national standards for early voting, vote by mail, voter list maintenance. I won't go on and on, but it was a really substantial bill. It died in the Senate. It didn't make it through the Senate. But it sort of got closer, I guess, in a way, than other major election reform bills had gotten in a long time. But I do want to say, even if it had been passed, those are federal standards that come down to states and local governments. It's very hard to enforce those kinds of laws. And I know, because at the Department of Justice, that's what we did. We enforced federal laws against states and local governments, and it's very challenging, in part because of this sort of hyper-federalization. So, okay, maybe you strike out at the federal government until you move to your state. And I know that later in the week, you all are going to be talking about specific kind of voting rights provisions and ballots and all that. And the truth is, I think about election law, but I'm not an expert on Arizona election law in particular. But it seems to me that we've had a number of competent secretaries of state and election officials at Maricopa County for some time. After Governor Katie Hobbs was elected, she convened, I think, what she called a bipartisan elections task force or elections commission. And out of that bipartisan commission came some executive orders or regulations that she enacted. Right now, I know that the legislature is very concerned about the amount of time it takes for Arizona to count its ballots. I understand the concern. It's not a huge concern of mine personally. I'd rather that things get done carefully than that they happen right away. And I think that elections are complicated. But we kind of live in a TikTok world where everything is ready in 6 seconds or whatever. And I understand the pressure to get our elections done quicker. It does feel like it can take a while. And so there was recently a bill passed by the state legislature that I believe Governor Hobbs vetoed because she felt that it would also sort of decrease opportunities for voting. So Hopefully there will be a way for the legislature and the governor to work together. That's the beauty. This is the beauty of checks and balances, right? That sometimes the two parties actually have to come together, and maybe hopefully there'll be a good result. Maybe nothing will happen. And I'm happy to talk more in the Q&A about things that, you know, I'd like to see, but like I mentioned, I'd love to see more interaction between state officials, local officials, and tribal leaders. I'm worried about folks who can't make it to the polls. I'm worried about defending things like vote by mail, which maybe there's sort of some kind of political movement to restrict it, or at least nationally. So there are things that, you know, that there's always work to be done, and there's work to be done, I think, because of federalism at sort of a number of different levels. So I will stop there, and happy to engage in a conversation with Professor Beienburg or to answer any questions.
We're going to do precisely that. We are going to bring Professor Beienburg on.
I'm back.
Oh, you're back. Okay. All right. Great. Okay. You're both on. Okay. Grace, we need to bring you on too, because you're going to be asking some questions. So start your video so we can bring you back on. We have some questions. So while Grace tees up a couple of questions, Professor Beienburg, in one of your slides, you talked about the supposedly very leftist governor statement regarding the interpretations of the Supreme Court. I was surprised to see that. We feel quite, and I don't think I'm alone in this. I mean, there's this real sense of the Supreme Court actually doing quite a bit of that overreach and stretching, you know, to interpret the Constitution instead of, or to, you know, make some legal decisions based on their interpretation. Can you speak briefly about that? And then I'll turn it over to Grace, because we have two interesting questions that I'm sure will generate some conversation here.
Sure. I mean, I would say that there are relatively few places in the last few years where we've seen the U.S. Supreme Court. The most controversial interpretations it's done, I would say for the most part, have been basically withdrawing federal power. So like the Dobbs case is fundamentally saying we are handing this power back to the states on both separation of powers and federalism grounds. Now you might say that's a bad interpretation, but it is handing power back. And that's what Hunt was speaking about. So he's coming from the context in the 1910s and 20s, where this is really the rise of the doctrine called substantive due process, where the Supreme Court is arguing that there are sort of rights that are more tangentially related to the text of the Constitution. So in that case, it was basically right-wing libertarian judges arguing that there was like a liberty of contract that was binding on the states. And so someone like George Hunt says, look, we want to do all kinds of experimental economic regulations that you right-wing libertarians in DC may not like, but like leave us alone when we do that. You don't have the authority to tell us what we can and can't do at the state level unless there's a piece of pretty clear constitutional text. So from Hunt's perspective, the real fear was in the Supreme Court, and this goes back to the anti-federalist skeptic Brutus, who argued the Supreme Court would be interpreting its power to be expansive, but particularly interpreting federal power to be expansive. And Hunt was critical of that. So I take Hunt to be basically saying he's particularly concerned about federal overreach, particularly in spheres where there's seemingly a much more tangential connection to the text of the Constitution. So that's the context from that quote. And so that's what I was alluding to. So for example, that same doctrine, there are conservatives that are arguing that there should be a constitutional right to parental choice. And there's a couple cases or school choice. And there's a couple cases from the 1920s that suggest that. That may be something that is pretty controversial, I would say. And so to the extent if particularly progressives want to push back on that, they're going to want to be making the arguments that George Hunt was making and saying, this is really tangentially connected to the text of the Constitution. And so you don't get to basically judicially enforce this. And this is a state issue. I don't know if that answers your question, but I think that's right. I think that's
Yeah,
what it was.
yeah. I was more interested in tangentially drawing in the immunity decision by the Supreme Court, but I'll leave that be for now because there's a ton of questions popping up, and I want to be sure our attendees have a chance to get their questions answered. Grace, you want to go through those? I'm marking them as live because these are the experts need to weigh in on these.
Yeah, for sure. So our first question asks, not sure if I'm asking this question correctly, but with the politicization of our military and the firing of JAGs, what can be done legally to ensure military power is not abused? ... Could Trump send troops to Arizona to put down a protest?
You want to start with that one?
Sure. Not about elections exactly, but yeah, so could Trump send troops to AZ to put down a protest? I'm not an expert on this at all. You know, I mean, there is something, certainly there's something called the Insurrection Act, where the president has the authority to bring in federal troops or to call in National Guard in order to, you know, quell public unrest. The sort of legal standard about what makes something justify invoking the Insurrection Act is something that I don't know, truthfully. If Professor Beienburg does, I would love to know. But you know, I think the broader question that you're asking is, you know, you say sort of what can be done legally to ensure military power is not abused, and I think the concern arises from this idea that President Trump is in a way consolidating federal power under the office of the presidency, right? And so the executive branch is vast. The executive branch is, of course, headed by the president. But there are so many agencies. There's the military, right? We're talking millions of people, and that's if you don't even include the military. The federal bureaucracy has, I think, something like 2.4 million people. And historically, there has been a set of the federal bureaucracy that's quite independent from the president. There are these things called independent agencies that sort of operate independently from the president. What President Trump is doing now is sort of engaging in an effort to make independent agencies less independent by removing officers of those agencies. Now, I'm happy to go into sort of like the long history of whether or not independent agencies are constitutional, because the court has been thinking about this for a very long time, and I actually think is probably ready to say that independent agencies might not actually be constitutional. We're not totally sure, I think. Well, that is an issue that the court will for sure address in the next 2 years or so. But the fear, I think, I understand the fear. The fear is that that President Trump is sort of attempting to consolidate the power of the executive branch and control more of it than presidents had in the past, I would say, or at least in the recent past. And so when we think about checks on the president, right, independent agencies are a potential check. And maybe those are sort of going away. An independent military, or a sort of, you know, a military that, I don't know if independent is the right word, but a military that isn't filled with loyalists, I guess, or presidential loyalists, is something of a check. States are a check. The courts are a check. The political process is a check, right? And so the worry is that checks are decreasing. If the federal bureaucracy is no longer a check, then where do we look for checks, right? Certainly the political process exists. Certainly states exist. And so I think that's actually where we should be looking for checks, in the substance of federalism, and via the political process as well.
And so I would just agree. I think that I've been telling people, I think the most likely shift that the courts are going to do in the next few years is a strengthening of the unitary executive, which is easily misunderstood. So the unitary executive is a theory of chain of command within the executive branch. It is not a theory of the actual scope of power in the executive in terms of what it can reach. That's a separation of powers claim. So the Trump administration has been calling for the overturning of a case called Humphrey's Executor, which is what Professor Weinstein-Tull was alluding to, which basically says that there's these independent agencies. Conversely, the argument is like there is no Article 1 is the legislature, Article 2 is the executive, Article 3, like there is no like Article 1.5, right? So I don't think it's totally an outrageous position to take that like, no, this is ultimately part of the president and the president is accountable on those grounds. To the question about the military power and the troops being put down, he alluded to the Insurrection Act. There's sort of three pieces. We've got the Insurrection Act, which says that the federal government can bring in the military under certain circumstances, but as he alluded to, it's sort of hazy what those are. Article 4 says that the president can basically bring in troops if at the request of the governor or the legislature, which presumably isn't going to happen. The complicated wrinkle builds on. We also have the Posse Comitatus Act, which says that you can't use military power for basic lawmaking. So the wrinkle is the interaction of the Posse Comitatus Act with the Insurrection Act. Under what circumstances can federal troops be deployed? But basically, it would have to be for a demonstration of like systematic lawlessness where federal laws can't be operated. So the classic case of this is in the 1890s when Governor Cleveland deployed troops to put down strikes and insurrections that had disabled the mail system in Illinois. The argument was like, this is a constitutionally enumerated guarantee. If we can't do this, federal authority isn't happening. But the threshold on that is pretty high. So I think it exceedingly unlikely, both as a matter of law and frankly as a matter of politics, that Trump would send troops to Arizona in any regard like that. But I could be wrong. For once, I could be wrong, but I'd be pretty skeptical.
I guess if I could add one thing, which is, it would be that if we are at a point where President Trump is bringing in troops into Arizona, and that's sort of accepted by the electorate and by the states and isn't met with a ton of pushback, then this country is in a very different place from what we thought, I think. I think that would be deeply unpopular with the electorate for a whole lot of reasons. And I suspect that the federal government, the current federal administration is still going to be sensitive to what's politically popular and what isn't. I could be 100% wrong about that. I really don't know. But, if that's the point where we're at, where that it's accepted by the electorate and sort of, then I think we're in a different kind of place than we thought.
I was going to say,
looking forward to 2026 in midterms.
Yeah, so I mean, I'm sorry.
No, go for it.
2026 is to me a very, very important moment. And that's because, like I mentioned earlier in response to this question, I think part of what scares people about this administration is this worry about checks, right? There's no check from the legislature because it's a fully Republican legislature that doesn't seem willing yet to push back on the administrative priorities. They're not sure how much of a check the courts are going to be. They have been in the past, but it's also been a mixed record. 2026 is the chance, provides a chance to create legislative checks, right, via the midterm elections. So that's why I think that's an important moment, because in general, we like checks on power, right? That's why the framers created a separation of powers, and that's also why the framers created federalism. It was to check power.
I'm just going to expand on the 2026 question here, since it kind of connects to it as well. So just national emergencies is actually a much more limited set of capacities. It effectively allows, there's a couple of different statutes that allow it, but effectively it allows the imposition of tariffs and reallocations of money. Like there's no sort of like national emergency and therefore like martial law kind of provisions or something like that. So, but to the extent that to the extent that people are concerned about national emergency powers being used, the best check against that is a separation of powers argument claim to say that this delegation should never have happened at the federal level, at the presidential level. A lot of state governments, in fact, the legislature actually here pushed that. Voters voted it down, but other states have done it to basically clamp down on emergency powers by the governors at the state level. But I actually think that there is very little that John Roberts would like more than to issue opinions clamping down on executive power in the sense of policy making. I think that the Roberts Court is very interested in allowing executive power in terms of chain of command. But I actually think this is a really promising time for those who take a stricter view of separation of powers, because Roberts and crew would be able to basically issue opinions that are critical executive power. I think, for example, of the DHS v. Regents case from a couple of years ago, sort of clamping down on that. So I actually think that the courts will actually be strikingly receptive because they would be able to get their doctrine through while being able to say, like, well, this doesn't look partisan because it's us like going after Trump or something. But I could be wrong on that. But I actually think Roberts and crew would be quite receptive to those kinds of arguments in the next few years, much more so than Congress appears to be.
Yes. Yes. Grace, I think the first question regarding emergency powers, Sean sort of touched on that. So let's move on to the one on cybersecurity and infrastructure.
Yeah, the next question that we have for you, gentlemen, is the Cybersecurity and Infrastructure Security Agency has been ordered to stop all election security work. Will and can governors step in to fill the security gap? What's the impact on future elections?
This is way outside my pay grade, so I have no idea.
Yeah. So anytime we start fiddling with election machinery, I start to get a little bit nervous. This is a federal office that looks at election security. There are sort of regularly threats to election security, some of them that come internationally. And I believe that it was sort of a federal, agency that worked with states and local governments to help buttress them against any kind of sort of security issues with their elections. We care about election security, right? We should care about election security a whole lot. And although we're benefited by the fact, like I mentioned, that elections are so highly decentralized, and it's hard to sort of like corrupt them all at once. The flip side of that is that there are sometimes very small and resourceless local governments that are administering elections. Local governments that don't have resources to think about election security concerns. And so it's really helpful to have those governmental bodies like the federal government and the states think about those big picture issues and then work in cooperation with states and local governments to help them manage issues that they might not themselves be able to kind of handle. So, sure, will governors be able to step up? They might be able to. Governors that want to might be able to. Governors that want to use their resources in this way. Governors that have legislatures that want to parcel out their resources in this way. I suspect it won't be a huge issue for local governments that are resource rich, huge local governments like, say, Los Angeles, right? That is a very, very sort of professionalized kind of election administration. But there are a whole lot of local governments that have one person who's, administering these things with volunteer polling workers. So, I think I wish that we still had those resources. On the other hand, this wasn't the federal government reaching into state authority to say, we want you to run elections in this way. It's the federal government declining to provide assistance that it had previously provided, right? So I would be more worried if the federal government sort of says to states, you must administer elections in the way that we're telling you, rather than stopping to provide resources that they currently provide. But still, I wish we had that resource.
Professor Weinstein-Toll and Professor Beienburg, we are going to ask one last question, and then we are going to wrap this up. So, Grace, if you can take that last question, please.
The question asks, when we think of the SAFE Act, do you agree that the Fed has the right to impose the proposed restrictions on voter registration? Do you have any thoughts on any issues proposed?
Professor Beienburg, do you want to
I was going to say, I mean, as he alluded to, the elections clause is very sort of ambiguous in that sense. I mean, there's a role for the feds, and there's a role for the states, and there's a role for the feds, and how expansive that sort of regulation on the manner goes is kind of messy. My thought is that it's complicated, and I will defer to an expert beyond that.
Yeah, so my thinking is, so I mean, I don't know exactly what the questioner is talking about, but I think we're talking about sort of proving citizenship and documentation and that kind of those kinds of requirements. So yeah, I mean, in general, you have this like push and pull between election security, which is the idea of preventing people who aren't eligible to vote from voting, and election access, on the other hand, which is not preventing people who are eligible to vote from voting. And so questions like voter ID, citizenship requirements, touch on exactly that tension, right? So the folks who are really who are concerned about election security and people who aren't eligible for eligible voters voting tend to advocate for voter ID measures, and those who are more concerned with voter access are worried about the burdens that these laws place on people by forcing them to have proof of citizenship and ID and all that. My general thinking, because we have the filibuster in the Senate, it's very hard for any one party to push through federal regulations when it comes to election law, unless it's like explicitly about spending, which can bypass the filibuster. So, unless the composition of the Senate changes, I'd be really surprised if an act that only required voter ID actually could make it through the federal government. Now, you might be able to have something of a compromise bill, right, that both expanded access and also promoted election security. My understanding is that that's not what's sort of on the plate with the SAVE Act, but so that's what I think about that.
Grace, I'm going to take this very last question of interest to all of us as the League of Women Voters is the ERA and all the convolutions that went through. Our last president said that has become part of our Constitution. Can you speak to that, both of you, please?
I mean, I think that that's a pretty tough take, I think, to make. I don't think it's striking that the archivist declined to do that. I mean, even Ruth Bader Ginsburg herself argued that the expiration date on that has been cleared. That's independent of even controlling for any of the rescissions. So now the counterpoint to that is that functionally, the courts have used basically what's called intermediate scrutiny plus to be skeptical of most regulations that have sort of a sexual discriminatory component to them. So in practice, it's not even clear what the difference will all be that based on the current doctrine. But I mean, I just think as a sort of fair reading of the law and what was in the amendment proposal, I don't think the Biden administration was on very firm grounds in saying that, which is why it was basically done as a tweet and a press release rather than anything beyond that.
So I'm glad you sort of brought that up, because there are documents floating around, little booklets of a revised constitution with the ERA in it. How valid is that?
People can print whatever they want, but I don't think any level of the government is going to be operating with that. But again, I think functionally, most of what the effects were have already been incorporated through doctrine from the 1970s. But I don't know if Professor Weinstein-Toll concurs or disagrees with that.
Yeah, I mean, there's a wonderful paper by a Yale Law School professor called the de facto ERA, which is all about kind of the defeat of the ERA and the way in which the legal principles behind the ERA came to be incorporated into a Supreme Court case law. Nonetheless, in the 70s and 80s, where the Supreme Court started to take up the idea of expanding the Equal Protection Clause to protect sex discrimination, I think that because the archivist didn't add it into the Constitution, it's a hard case to make that it's currently part of the Constitution. That said, this is a space for potential advocacy, right? If you're someone who believes in the principles of the ERA, and I think actually probably a lot of us believe in the principles of the ERA, or the idea of equal rights for women. Advocate, right? I mean, there are ways to amend the Constitution. And in fact, ASU last spring hosted a model constitutional convention. And it was really fascinating. And it was a really productive set of conversations. And, you know, it's hard to make change, to make lasting change in this world, but where you start is via conversations, like the conversations that happened at the Model Constitutional Convention, conversations at the local level, conversations at the state level. You build support, you build a groundswell of support. Because of our system of federalism, it's hard to make change that's lasting national change unless you have a real broad base of support in the country. So, you know, it's a space for advocacy.
So Professor Weinstein-Till and Professor Beienburg, I would be remiss in not kind of saying we have been fighting and advocating for the ERA. It is not something new. So to hear that it is really not part of the Constitution is not something that makes any of us as League members either happy or the people who've been fighting for it for quite some time. Because, you know, when you talk about it's in practice, okay, being impacted, it's in practice being implemented. The fact of the matter is, but it still doesn't afford any legal protections. And without it being, you know, there are no constitutional protections without it being part of the Constitution. So with that, you know, we could probably go back and forth, but I would be very remiss in not bringing forward the years that the League and League members across the country have been fighting for the ERA and the passage of the ERA in all the different states. We're in 51 states. So,
well, look, let me say, I mean, we are not, neither Professor Beienburg nor I are on the Supreme Court. We don't interpret the Constitution. Bring a case in court, test it. Let's see, is it part of the Constitution? You know, I mean, it's find an opportunity to test whether Biden's proclamation was binding. And at the same time, because it's something that the League cares about, keep fighting for that thing, keep building grassroots support for that thing, and use federalism as a tool for that support.
all right. With that, we are going to thank Professor Weinstein-Till and Professor Beienburg for an excellent presentation. We are delighted that everybody who could attend had a chance to hear this. The event is being recorded and we will have it on YouTube. We ask that you follow us on social media and more importantly, become a member of the League. As Professor Weinstein-Till said, we need folks to help us fight the good fight and to make sure that ERA and, you know, there is equity and that there are voting rights and making sure everybody can vote, which is very important for that. So we'll end with that the League continues to defend democracy.